So we'll start with the boring legal stuff. This legal disclaimer, this talk is just provided as general information and should not be construed to, nor does it intended form the basis of a attorney-client relationship. I'm going to assume any questions are hypothetical, but if you do have any, feel free to ask. My answers will be as general as possible. And if you do have a current legal issue, especially related to your game development, please contact an attorney and deal with that. So overview, two big topics, two questions I want you to be able to answer when you leave. What is intellectual property? How do you protect it? It's a huge topic, so we're going to be a little bit of a mile wide and an inch deep here tonight. And kind of like Sonic, we're going to have to go fast. So what is IP? IP as an umbrella refers to creations of the mind, such as inventions, literary, artistic works, designs, anything creative, anything created sort of by human ingenuity. At least according to WIPO, the World IP Organization, they handle most of international IP trend sort of recognition and understanding in a lot of the treaties. And how do you protect it? Really depends on the type of IP, but generally speaking, it's through registration with either a certain government body or something like that, and active enforcement. I mean, these days you have to be kind of looking out for people who are infringing on your IP, especially if it's a trademark. There's four basic types, sort of the four overarching. You've probably heard of at least a few of these before: patent, copyright, trademark, and trade secret. Each covers a different sort of creation, different area, and they are fairly exclusive. We're going to spend most of our time on probably copyright and trademark, but I will go over patent and trade secret very briefly. So what is copyright? This is the language of the statute, but essentially what we're trying to say is anything, or any form of artistic expression, regardless of how it is created or what it is reproduced on. So whether it's a painting you do on a piece of paper, something you do that you play with the aid of a computer, anything like that, we want you to be able to be protected, provided it is a work of artistic expression. Specifically enumerated in the statute are these 8 categories: literary works, musical works, dramatic works, pantomimes, pictorial and graphic novels, motion pictures and other audiovisual works, sound recordings, and architectural works. Most forms of expression fit under one of those, including video games, other audiovisual works. But there is one limitation. There is no copyright protection to authorship of an idea, procedure, process, method of operation. So basically what we're saying is, and we'll get into this a little bit more, copyright is designed to protect expressions, not ideas. And then some other things that are not protected: names, titles, slogans, short phrases, domain names. Those are all trademarks. So if you generally trademarks, very brief peek ahead of what's coming. Trademarks are for telling someone where your goods come from, or who made them. Quick rule: copyrights are among the longest lasting of IP. Currently, they are the life of the author plus 70 years, or in the case of anonymous, pseudonymous, work for hire, or when a corporation owns the copyright, it's 95 years from first publication or 120 after creation, whichever comes first. So as you can imagine, generally these will last quite a long time. So what rights do you get? So with copyright, you might think of it as sort of a bunch of different tools. You own these 6 rights by having a copyright: the right to reproduce the work, the right to adapt the work, the right to distribute the work, the right to perform it publicly, the right to display it publicly, and generally not in the United States, what are called moral rights, which are allow you some measure of control over how the work is used, even if you've granted it out to other people. We'll go over each in turn. So reproduction, very simple: the right to make copies. So the simplest example is if you have a picture, the right to make pictures, photocopy books, copying a computer program, those all fall under reproduction. So the original author or whoever currently owns the work has a right to control those. I've just given some examples here. Adaptation. This is a very big one lately just because it's the right to create what we call derivative works, which are taking one work and translating it into something else, whether it's just using bits of something in a YouTube video and then adding onto that, or if it's turning a novel into a film. So basically, if you created something, you have some measure of control over what other people do with it. But this, of course, is balanced by 2 words most people have probably heard: fair use And I forgot to mention, if you have any questions, feel free to raise your hand. I'll try to get to any that I see. I'll hopefully not go too fast. Distribution kind of walks hand in hand with reproduction, but it's the right to control who gets to hand out copies, who gets to distribute this. It's very common in the case of digital works because you now get to control who gets to make copies. In the case of physical works, there's what's called the first sale doctrine, which basically means if I sell you a book, I can't prevent you, at least under copyright law, can't prevent you from selling that to someone else later on. Now there are issues in contract law where I could sell you a book on the agreement that you won't sell it to anyone else, and I can enforce that contract, but I can't necessarily, if we just had a basic exchange, I can't stop it, at least not under copyright.
Is that where pirating comes from? Or is going against that? Is that how pirating is?
Yeah, generally speaking, piracy involves either unauthorized reproduction, distribution. It depends exactly on what's going on with the form of piracy, but generally speaking, that's the right that you're looking at. Next, we have public performance. This is basically whether you can show a work to a public group, like whether you can show it in a movie theater or whether you can stream it on Twitch or whatever you have to be doing. So the definition of what constitutes public is reproduced here. Basically, anything outside of one's home generally would be, to a place where lots of other people can see it, would generally be considered public. So, like I said, includes performance transmitted to multiple locations. So some big examples being Twitch and YouTube for video games, a lot of streaming these days. Or if you show it in a park or something like that. Public display is basically the same thing as public performance, but covers still works or things that aren't necessarily moving, things that you don't play for other people, but you show them off, like a painting or something like that. And they have pretty much the same definition of what constitutes public as the public performance. Moral rights, we generally don't recognize them in the US, only a few of them do we actually recognize. But they usually include when they are in other countries. EU is very big on moral rights. It's the right to attribution, so no matter what, your name's going to be, you can guarantee that your name goes along with whatever display of the work or whatever use of it. One that we do have in the US is the right to publish anonymously or pseudonymously. And then the last one is the right to the integrity of the work, which we'll go into in just a second. Yes? Since some of you may have games that go out in the EU or other countries that recognize these, I wanted to bring it up very quickly. Basically, it allows you to prevent, you as the author, to prevent distortion, mutilation, or otherwise someone taking your work and using it in a way that is just absolutely the opposite of what you want. So maybe you've created a character that strongly supports some, maybe a political view or something like that, and someone else takes it and just completely warps it. In places with moral rights, you can somewhat prevent that from happening. And one key from the other rights we talked about is where they're recognized, they're distinct from economic rights, so you can't necessarily contract them away. They're much harder to contract away. With copyright, registration is not required. You don't have to, you get a copyright the moment you create your, whatever it is you've made, whether it's a painting, literary work. As I said, as soon as it's fixed in some tangible medium, some way we can give it out to other people or display it for other people. But there are good reasons to register your copyright, very good ones. But we're going to skip that for 1 second because this is just getting what authorship is. You are the author as the creator, with one exception, where it's a work for hire. A work for hire is something you do as an employee within the scope of your employment. If you work for a game studio, anything you create under that employment is owned by the studio. Or in the case where a work is specifically commissioned by one person to a non-employee, they agree in writing, and it has to fall in one of these categories. They are very specific, they have specific interpretations, they're all they're things where it kind of would have to exist in order to make copyright even work. Like, it would be very difficult to have, say, a translation where the translator now gets to own the copyright in the final work. But they do show up in portions of motion picture or other audio-visual works, so they can show up in a lot of the video game space as well. But back to registration. There are several advantages with copyright. It's relatively inexpensive. Just to do it yourself, it only costs about $35, and that's a filing fee. It establishes a public record, and if you want to sue in federal court because someone's infringed your copyright, you have to register. And as the last benefit, if you did it within 5 years of the first publication, it becomes prima facie evidence of copyright. So basically prima facie meaning initially sort of on its face. Your copyright will be presumed to be valid unless the other side can prove it wrong or can show that you did not have a right to this. And just continuing on, if made within 3 months of publication or prior to infringement, you get statutory damages and attorney's fees. Yeah.
Well, I was just curious, where are, or under what umbrella of law are copyright? I assume it's its own, but is it really at a state level, or at a county level?
Oh, it's federal.
Okay.
Copyright is, most of these are, copyright, patent, and trademark are federal. Trademark also has state protections. Trade secret just got federal protections, I want to say about a year ago. So normally, like I was going to say, if you register, you can get statutory damages. So there is actually a statutory rate you can get based on what the other party did, and possibly attorney's fees, because we all know lawyers are expensive. And if you don't have that, it can actually be very hard to prove damages. It's very hard to prove if they just took a brief portion from your novel and copied it. It's hard to prove how much of their resulting work yours contributed to. Litigation, a big part of litigation can often be damage calculations, which of course is very expensive. And then of course you can record it with the customs service to prevent improper importation. Fair use. I'm sure most of the people in this room have heard those words. It is a defense in copyright law, and as a defense, it's usually sort of argued in the alternative. You're probably not going to show up and say, yeah, I infringed your copyright, sorry. But you're going to say, well, if I infringed, that it was fair use, come on. Basically, the reason we have fair use is courts noted that too strict an application of the general infringement statute would stifle creativity. You couldn't even quote a book in a book review. You couldn't share copies of a news story. You couldn't, if you're filming on the street and something copyrighted happens, you happen to walk by, you've now infringed. So we needed sort of a balance. So we look at a 4-factor test. There are 13 federal circuits. Each one modifies this a little bit, but generally speaking, they look at these 4 things. First, we start with the purpose and character. What are you doing with this work? The nature of the copyrighted work. What kind of work is it? That does weigh in on what it is or what's allowed. How much did you use, and did you affect the market? So for purpose and character, we have a number of factors. First, favoring fair use if you're using it for educational or teaching purposes. If you're using it just on your own, you're not distributing it, you're just using it in your own home. Don't know how they would have discovered it in that case, but you know, in that. If it's for research purposes, or if it's a very transformative sort of use, like you're criticizing it, commenting on it, making a parody of it. Parody is a little dangerous because everyone can call their thing parody, but what it actually comes down to kind of depends on what the judge and jury say. So, and factors that oppose it, if you're doing something for profit, if you're doing it for the entertainment of others, if you have a commercial intention, and if you don't attribute to the owner. Nature of the copyrighted work, we favor works that are published, fact-based, or educational. It's disfavored for unpublished works on the assumption that maybe the author didn't want that distributed for some reason. Fictional works, because we kind of think that something someone made up versus something that is based on real happenings, we're going to be a little bit stricter with. Creative arts have always had sort of a high protection. They've sort of looked at as an elevated form. It's going away a little bit, but they still have that sort of extra boost. And it's supposed things that are designed to be consumable, like workbooks for education. We don't want people to just go make photocopies of those and not, well, at least the publishers don't. Portion of work used, pretty straightforward. How much did you use? Was it central? You know, if you use a tiny piece from a background image on someone's painting, maybe less than if you use the main image itself. And if you're using it educationally, like that. If you copyrighted infringed on pretty much the entire work, or used very central characters, themes, images, whatever, depending on the nature, that is less likely to be viewed as fair. And then of course, effect on value, it is literally just weighing all the factors to see, is the author of this work going to get less money because of what you did? So it's going to look at how many copies, did you affect the market, Did you try to get permission? Did you do it only once or twice, or for a limited time? And of course, all those are balanced by their opposite side. Yes, as one of my law school professors like to say, it's never fair use until a judge says so, which means you may think your use is fair use, but you're going to have to go to court to fight it out, unless you can convince the other side so strongly that their efforts would be wasted. So as a creator, you have to consider the factors that I just listed and ask yourself, how close am I? Since we're video game people, software is important. It is eligible as a literary work on its own. Graphics, sound, appearance of programs, they can be protected as audio-visual works. And you can prevent the literal copying of your code and to some degree non-literal elements. But this is where that idea expression thing I mentioned earlier really comes up, because you only get to copyright the expression, like your way of doing that particular function. You don't get to copyright the idea of the function. So, if you have a very special way of displaying hello world, you might be able to get that, but you can't claim all hello world functions are going to be yours. What isn't? Things that are, things that can be done through an interface, generally not copyrightable. Generally, particular combinations of user interface elements like file, edit, window, review are generally not copyrightable. You're getting close to sort of trying to copyright facts and methods instead of actual artistic expression. And so I've said it several times, idea and expression, but copyright protects expressions, not ideas. And with code specifically, consider the expression of how you did it versus what was sort of the overarching idea of what you wanted to do. So this is I will promise to only do one audience participation thing. You don't even have to talk. But when I say the idea of a space soldier, just take a second, think about what pops into mind. Let's go with a video game character if you can. Everyone got it? And obviously everyone thought of Doom Guy, right?
Wait, no.
Just me?
That's machine.
Doom Guy.
Yeah. So the idea of a space soldier, that's one example, but then maybe you're more of a For the Emperor type. You might be a Blizzard fan, or maybe you prefer the local boy. All of these could be described as a space soldier, but each one is its own expression of that idea. So just an example, that's sort of there's many ways to use them. So all those different characters are copyrighted by their owners, but none of those people owns Space Soldier, though admittedly Games Workshop owns Space Marine as a trademark, but that's a whole other story. This is also further balanced by what's called the merger doctrine. At least according to the Ninth Circuit, which is where we are, Washington, Oregon, California, Idaho, where the idea and its expression are sort of inseparable, where the idea is perhaps so simple or so well understood that you can't really express it in a unique way per se, you don't get to claim that because you basically now have an idea. So describing a red apple on a table, I cannot copyright that sentence. And it's probably one of those things where merger doctrine is going to prevent me from claiming it. Yeah, as I said, sort of the idea and the expression have merged to the point, usually with simple things, to the point where there's really no way to do it any other way.
So could someone else come up with a blue hedgehog game and not get sued?
It's very hypothetical. You'd have to be very distinct from a certain well-known blue hedgehog. Maybe don't include a flying fox or a red echidna. Then there's very similar to the merger doctrine, it's called sans affaire, French for scenes that must be done. It's basically, you can almost think of it as the doctrine of tropes, like no one can claim tropes. Basically protects things that are just so well understood to be part of a particular genre or form of expression that nobody gets to claim them. Dragons in fantasy settings, cowboys in saloons in a western, spaceships and weird planets in a sci-fi setting, things like that. Just things that are, so common that pretty much everyone has done them or every possible. But there is no clear line. I can't tell you exactly this is sans affaire, this is not, and it varies from jurisdiction to jurisdiction. Like I said, there's 13 circuits. Each one has a slightly different interpretation. So you want to err on the side of general ideas versus specific ones, like dragons versus dragons that happen to follow Daenerys Stormborn. So this is the where you get in trouble. infringement. Copyright, someone violates one or more of those rights that I listed at the beginning, and it comes in two basic forms. Either the person is a direct infringer, or secondary, which means they helped infringe. Direct infringement, pretty straightforward. You violated one of those rights. You reproduced, you made a derivative work, you publicly performed. It doesn't even need to be the complete work. You just have to be substantially similar, and if someone can find a perfect way to encapsulate what that is, the courts will love you, but so far it's very much a test. So juries are gonna have to tell you what it is. But if you say just change the character's name, published your own novel, that's probably not gonna be enough. That's pretty close to secondary is contributory infringement. You had knowledge of direct infringement. You either encouraged or assisted. Maybe you helped them, you provided them the printer, you helped store some of these infringing works. And then vicarious, you had the right ability to control infringement and derive perhaps financial benefit. This was some of the arguments made at companies like Napster early on. And like Boo, you can't just stick your head in the sand and look away and hope it's going to go away. If you know people are doing it, you have some responsibility on your platform to stop it. Do you have a question?
If someone basically distributes your content on Facebook, then does that fall under vicarious infringement?
For Facebook?
It's they're profiting. So.
We'll get specifically in regards to internet, we're going to get that because there's the DMCA, which helps prevent that. That does put some of the weight on the owner's shoulders to report when their works, because YouTube, Facebook, and a lot of those providers basically successfully argued to the legislatures that we get so much content, there's no way for us to curate it all. And that was their argument, and legislators agreed, so we have the DMCA, which I'll get to in just a moment. In fact, right now, the Digital Millennium Copyright Act, aka the DMCA, it has two very important provisions for general use. There are others, but these are two that you should probably know about. One is Anti-Circumvention. You're not allowed to try and get around people's encryption methods, and so if I hand you an executable, you're not allowed to try and crack it without my permission at least. And then the one that you were talking about, OSPs, online service providers, and ISPs have a safe harbor against infringement liability if they respond in a timely manner to DMCA takedowns. Right here, I'm getting ahead of myself apparently. If you receive a properly constructed notice from someone that they are asserting that their content is being infringed on your site, and you comply, you are safe, provided you do everything right. So basically, you have to respond to this takedown, take it down. Some websites, I'm sure you know, like YouTube, give the person who posted a chance to respond, and everyone does it a little bit differently, but generally speaking, as long as you have that procedure, you're more or less safe. And that's the end of copyright. Some great resources are, of course, the Copyright Office. They publish tons of circulars and information on all sorts of topics. They're constantly updating them. They're very good about it. And for fair use, Stanford has a great sort of internet resource of some examples of fair use and arguments that people have made. So now we'll step into patents. I'm going to go a little bit quickly on this one because it's less applicable to video games, but it's something that you may want to just get the gist of. Two big topics. What is a patent? How do you get one? A patent is a legal device that grants you the right to exclude others from doing something. Whatever it is you patented, you can prevent other people from doing what it says in the patent, or specifically what is claimed in the patent. Interestingly, it does not grant you a right to make your invention. So if you, for example, came up with an improvement to something that someone else has patented, you can prevent them from making your improvement, but it doesn't grant you the right to make whatever it is they patented. Does that make sense? Conversely to copyright, patents must be actual things, not just abstract ideas, but this is this form of IP that lets you protect ideas and concepts like that. The basic standards of the thing must be new and non-obvious, and good luck sussing out exactly what those are. I argue with examiners on a daily basis about what those are. Patent is much shorter. It's only 20 years from the date on which it's filed. Protection begins you can start enforcing the day the patent issues. You can get some amount of retroactive protection, but it is a little bit of an argument. And there are certain legal exceptions that allow you to reclaim some of the time you lose during the pendency of your application. So you file, then there could be about 2, maybe 3, sometimes even 5 years of application where you are fighting to get that issued. And now you only have 15 years left. So you can get some of it back, but it's very difficult. After that 21 period, your patent dies. There's nothing you can do, it's gone. We hope you enjoyed your money. Anyone can do what was claimed without infringing. So it's supposed to encourage you to continuously be innovating, continuously coming up with new ways to expand on that portfolio. There are 3 basic types. Utility patents, that's sort of what most people mean when they talk about a patent. There's also design, and yes, there are plant patents. They're very unique, very rare, and we're not even going to talk about them, but they do exist. Design patent, going very quickly, they protect ornamental features. They're relatively cheap, they're fast to obtain. Obviously, they tend to be physical objects only. Rounded corners, that famous lawsuit was a design patent. And it's intended to protect non-functional features. We can argue whether rounded corners are functional, but that was Samsung's job. Utility patent, they protect the functional aspect of the invention. So if I make a widget and it's unique, new, that's what I get. They can be very broad, depending on how the claims are drafted and what you invented, but they do not protect the ornamental look, so they lose that part of design. They are, from the statute, granted a new and useful process as machines, article of manufacture, or composition of matter. Any improvement on the following, sort of the process to composition of matter is sort of what the terms of art that patent examiners will like to use. It is a semi-adversarial process, but I'll get to that in a second. There's 2 types of utility patent applications, provisional and non-provisional. Provisional provides that filing date, because in the United States, all we care about is who got their paper to the patent office first. We don't care if you invented, we don't care if you can prove that you invented first. Whoever slid theirs under the door gets the filing date, and that person's going to get the invention. You now get, once you file the provisional, you have a filing date, you can use the term patent pending, and it doesn't take away from those 20 years. But it is just a placeholder. It, by operation of law, gets abandoned after 12 months. And if you're non-provisional, which is sort of the patent as you probably think of it, has to be supported by that provisional. So whatever you put in that provisional, that's what you're going to get out later on. They're not examined, they're in fact only published under very specific circumstances, so I am sure the Patent Office has seen some very interesting things. Even scans of napkins that people wrote notes about their invention on. That kind of stuff can go in a provisional. Oops. Go back one. Okay, so the benefits of them, they're very cheap. It's basically a filing fee and whatever time it takes to assemble them. You can sort of get your foot in that door while still being able to sort of develop, look for investors, things like that. And like I said earlier, the filing date does not count towards the duration of your patent. And as I said before, filing date is what determines prior art, determines infringement. Most of the world, except I think Cameroon and 1 or 2 other countries, use first to file. All that matters is who got to the patent office first. If 2 people had the exact same idea, it doesn't matter who invented first, as long as one got there before the other. 1-year bar sort of dovetails off that. Hopefully I haven't done too much on you. I know it's kind of infodump. Basically, after 1 year, after you announce your invention to the world or try to sell it to someone, you have to file an application. If you don't, it becomes just part of the public record, part of the public knowledge base. If you're testing something in your basement, if you give it to a friend, a prototype, that generally doesn't count, but if you try to sell it at a trade show, if you make a YouTube video, all that can count against you. Non-provisional, this is what people are talking about when they talk about patent. This gets the name in the negative, but it is the not provisional application. It is the full, the granted, the examined one, the goal. And so the basic process of a non-provisional is you file it, you get an office action, which is going to be the patent office saying no. You respond to that office action, and then depending on your response, depending on what you did, you'll either get a final office action that is again no, or you get a notice of allowance. That means you're going to get a patent. And if with final office action, there's options to appeal that. There's options to basically file what's called a continued examination, start the process over again. And each time you're changing your claims a little bit, you're making arguments to the examiner, trying to convince them that whatever prior art, whatever other things they found aren't what you made, or are different. What you have is unique, different.
Does Does anyone ever get a yes on the first response?
Very, very rarely. It's very hard to get. They tend to be very aggressive and very broad first, and a lot of drafters will draft patents somewhat more broad than they need to start, just because if you draft it too narrowly, then your client, from an attorney perspective, is going to get too narrow a patent to really enforce. So you kind of want to push that envelope a little bit. Just a quick summary of the timeline. There's what's called track 1, which gets you through the line faster, but it of course costs money, a fee to the patent office. But it takes anywhere from about 18 to 27 months if you go just the normal route. That's depending on the art unit, depending on what you filed. So can I patent what I came up with? I came up with a widget. Here's the question to ask yourself really quickly. Is it one of those? Does it sound like one of those? Can you justify it being one of those? Is it new? Has someone else done it before? Did you see it in a magazine? Did you happen to be really bored one day and going through patent applications and see it there? Google Patents is a lot of fun. Then it is not new. Is it non-obvious? Is someone else who knows about that discipline or art, would they have been like, oh yeah, we can do that, that's obvious, that's easy. This is where a lot of arguments get made, but it is one of the standards that the examiners, patent examiners who work for the Patent Office in Alexandria will be asking themselves. So what to do if you have an idea you think is patentable? Consider it, look for similar ideas, Google it. Sort of, as I've heard from a friend who's an engineer, if you can't go buy it, then he starts wondering if you can patent it, because if you can't buy it, maybe there's a chance no one's done it. The Patent Office has an awful, terrible search interface, but Google Patents has a great one. You can search those, just type in, sort of describe your invention, and it will try and match things. And you can always talk to a patent attorney. Most of them will give you at least a few minutes to just go over the basics without charging you anything. They might be able to give you an update. Software patents. These actually can come up in the development of a video game or any software. They are potentially eligible. Really depends on what it's doing. What they're looking for right now are non-abstract improvements to computer technology. So basically, this was the big case, Alice Corp versus CLS Bank International. Came down to the Supreme Court stating, just if you take an abstract idea and you add a computer to it, you don't get that. If we've been doing this by hand on a piece of paper for 1,000 years or however long, you can't just add a computer to the equation and patent that. In this particular case, the involvement was basically an escrow arrangement. It's an abstract idea, they added a computer, ergo, no patent for that.
So like Microsoft Word, we've been writing for forever,
Yeah.
but it's just on a computer, so.
Exactly. Things like where it's something that is well known, but you've just managed, and it wouldn't even be necessarily difficult to implement, you just happen to be the first person to do it, that would be very difficult. Like, it'd be very difficult to get the patent on. Though people did try, get a online shopping cart. That was something different, just because the idea of having a cart that you can store items in until you're ready to check out is very difficult. Or excuse me, it's relatively simple to implement once you've thought about it. So, but the exception, according to the Supreme Court in that case, was does it solve a computer-centric problem or improve the computer somehow? If it's a problem that is specific to computers, maybe they have a particularly difficult way of doing something, or no one's found a good way to do X, Y, Z. Maybe it's voice recognition, and you've come up with this perfect way to just suss out how to understand anyone, regardless of language or accent or anything like that, that could be eligible. But it's still a little bit uncertain. Alice is a relatively new case. Courts are still sort of figuring it out. So again, the bad stuff, infringement, is pretty much just like copyright, doing what the other person has a right to prevent you from doing. But the catch is in patents, you have a series of claims. They're just short sentences that describe what you do. Usually there should be instruction enough to tell someone how to do it. But for you to infringe, you have to do all of them. So if you do less than that, or in a particularly different way, you haven't infringed. The one exception is the Doctrine of Equivalents. It's a little bit of a complex argument, but generally speaking, it may not be exactly like the claims, but is 99% similar and is basically doing the same thing. That may still fall under it. If I say, if it has a rod and you use a square rod, that might be still an equivalent. Just like with copyright, there's basically two types of infringement, direct and indirect. Direct, of course, is you did it. Indirect, you got someone else to do it or you helped. And just for some resources on patent, the United States Patent Office has lots of information, just like the Copyright Office. They even have a kind of a hit list of all the abstract ideas they've shot down and had federal cases shoot down with them for software patents. It's basically don't try to get these. It's a big long list, but they describe them very well. So trademark. This is another one you'll probably see a lot of in this field. The sort of fancy description is a device that is used to identify goods. It's a source indicator. It's supposed to tell you sort of you, the consumer, where this came from. So when you see Apple, you know it came from Apple. Doesn't necessarily mean you know what, for example, what factory it came from, but you know sort of the person who was overseeing its construction, the person who had the final say. Benefits, sort of the policy behind trademarks. They reduce your cost of shopping. You can see a trademark and know kind of what you're getting. They're supposed to allow producers to get a financial reward from having a good reputation. People like your product, they'll come to you, so you having these good Yelp reviews will get you business. And it's based on that, it's supposed to encourage, other various manufacturers to make good products, so people will say, oh yeah, that Kyle Corp product is awesome, I love their stuff, let's go buy that. Trademarks, kind of like copyrights, they're created automatically when you start using them, but they kind of fall into two areas of law, state and federal. Most states have some way of registering a trademark, state of Washington does, but there's also federal registration. Under what's called the Lanham Act, you basically start getting trademark rights as soon as you start using something, but you do have to register to get some of the biggest benefits, we'll call it. What can be a trademark? Some examples of design trademarks, but stylized types. But you can have words, stylized types, special forms and shapes, and in some very rare cases, sounds and scents.
How do you give an accurate description of the scent enough to trademark it?
It's very difficult. You have to provide, the ones that did it, you basically have to provide chemical formulas. You have to show that people associate that scent with you. There are a lot of amusing ones trying. If you Google it, you'll get some great, maybe about 10 minutes of amusement at these companies that have tried. One, I believe it was, I want to say it was Samsung, tried to trademark a specific scent for their stores, so that the consumers would find, I believe it was described as pleasing and calming.
So Apple would have both the symbol and the sound. Is that two separate trademarks for?
Yes, for different types, you have to register them independently. Now, all the examples I brought up here are the stylized type or special form. Word mark will literally just be the words, whatever it is. So for any example here, Ubisoft also has a trademark in just Ubisoft. Blizzard, well, Activision Blizzard and Blizzard both have them. Pokemon has hundreds. So some examples, just another set, words, stylized type, and you can even get special forms and shapes. So the Coke bottle, that's sort of the more modern one, but the original Coke, glass Coke bottle. So why do you want to register federally? It counts as telling the world that you're using this. So if you register your mark, anyone in the United States is presumed to know of its existence. You can sue people to try and prevent them from using very similar marks. The federal government will presume that you're using it everywhere. There are special rules about if two people in different locations started using the same mark, what happens when they finally collide. But if you registered first, you have a benefit in that. Like I said, you basically have put everyone on notice the moment your mark is registered, and you get to use the fun little R symbol. Other benefits, after 5 years of being registered, your mark is considered incontestable, so it raises the bar for someone else to take away your mark substantially. Some would call it impossible. Gives you the right to sue in federal court to protect your trademark. You get, of course, statutory damages in the cases of counterfeiting if other people are using your mark and passing off goods as theirs. Just like copyright and patent, you can register with the Customs Service to prevent importation. And because of numerous treaties and the Madrid Protocol, you can use your U.S. registration as a basis to file in other countries, potentially get your mark in those places. Things to consider, what kind of mark you're doing, what are you going to be selling under that mark, what services, what goods are you going to give people, what's your overall strategy, and how are you going to look at it? Because unlike the others, trademark does require you be very vigilant. You have to be aggressive about preventing other people from using your mark. These are the various ways you can get rejected. We're going to describe these, but these are sort of the bases on which the trademark office will say, no, you can't have that. If your mark is generic, if you sell apples and you try to get the mark apples, they will kick you to the curb. If you're just describing your thing, red apples, delicious apples, crispy apples, they will kick you for being just descriptive, because all you're now doing is describing your work. If your mark is somehow deceptive, if it's illegal, there's still a lot of debate about cannabis-related marks, just as an example, because technically at a federal level it's illegal, but some states have allowed it. And until last year, marks that were considered immoral, which I won't go, but a sort of immoral or scandalous mark, for example, the mark that sort of removed this was an Asian American group of people started a band they called the Slants. They wanted to reclaim the name, and it was refused, and they sued.
Disparaging is another term.
Yeah. Disparaging is another way, or another sort of the term of art. They sued, the Supreme Court agreed with them, so now you can have marks like that. It's still, the trademark office is still actually fighting against it a little bit, but for the moment. So there's sort of a spectrum of what marks are strong, what are gonna get kicked, what are protectable. I'll give you an example on that, but just sort of think of the descending best and then worst at the top. So generic things, just describing your goods. Descriptive things, just telling me about the goods. So generic is the name of whatever it is. If you sell baskets, you can't register baskets. Partially because we don't want you to be able to prevent other people from saying, hey, I sell baskets too. Genericide is a unique experience. It's when a mark that was protectable loses protection because everyone just begins associating that mark with the goods. Cellophane, escalators, aspirin. Basically, the only way to prevent it is to try and educate people. That's why you'll see, if you've worked with any companies, they will often include to their vendors ways to describe the mark. You'll see ads. Band-Aid, for example, will tell you, I'm stuck on Band-Aid brand because Band-Aids are stuck on me. They want people to know it's a brand. They're trying to broadcast that as loud as they can. Because some that are at risk because a lot of people start associating Xerox, go Xerox something. Jeep, any SUV is often described as a Jeep. Band-Aids have often been called, bandages. And to Google something is in the dictionary, they're fighting it very hard, but they're afraid that they might lose their mark.
Realtor is another good one.
Yeah. Did you say that?
Realtor?
Yeah, realtor is another. It's basically when it's both a, you might think of it as it's a compliment, but it's a really backhanded one because now you've lost your mark. So a descriptive mark is just something that immediately tells you about what you're doing. Red apples, aluminum siding, if you sell those things, you're just telling people what it is again. But things that are potentially protectable, suggestive marks, they're ones that sort of allude to the goods or services without describing them. Nike, Greek goddess of victory, sporting goods, hey, we want to win. Microsoft just took two words that fit into the tech scope without describing anything specifically. Electronic Arts, regardless of how you feel about them, sort of suggests video games, but doesn't necessarily say it. Some could argue that Electronic Arts is descriptive, but it's sort of, that line is very blurry. Arbitrary, it's basically just when you come up with a random word that you associate with the goods that has nothing to do with them. Apple or Sun for computers, Blizzard or Valve for video games. That doesn't really describe the games unless they're making very snowy video games or a lot of things about pipes. The line between these suggestive and arbitrary, sort of up to opinion. Some people call something suggestive, some people call it arbitrary, but it's sort of up in the air. But either way, you're on the safe side of the line. And then fanciful, made up words, something you made up. Kodak, Xerox, Exxon, Ubisoft, Sony. Basically a word that has no meaning outside of its use as a mark. Those are, well, trademark examiners would love it if that's all we ever sent them. Easiest marks in the world to get, but sometimes it's hard to convince your customers what a Xerox is or like that. So some examples, just using the same word. If you sell camels, or if you sell camels and use camel, you're generic. If you have camel hair plus clothing for clothing made of camel hair, you're descriptive. Camelback, however, a little suggestive. Oh, camelback, it's water that goes on my back. Oh, I'm like a camel, okay. And then arbitrary camel for cigarettes. It doesn't have a known association. One exception is what's called acquired distinctiveness. That's basically when you use something so well or so long that everyone just assumes that they see that word and they think of you, even if it should be descriptive or even sometimes generic. Mostly just descriptive, excuse me. But you have to have done it for at least 5 years, so for a lot of marks that can be very difficult to show that you were the only person doing this for that time. Trademark registration process is very similar to patent. You look for it, you apply, you go through an examination, it gets published, and after that publication, the one exception for trademark is unlike patent, there is a publication where other people can come forward and say, hey, I've actually been using that longer. Here's my evidence. But if you pass through that period, you get a trademark. So basically the search part is you just Google it. Look, you use the USPTO system or even just Google, see what I did there. You basically are just looking to see if anyone else has used your mark. And if you ever go to a lawyer, it's the first thing we're gonna do. You prepare an application, you can actually do this on your own if you want. But you basically fill in information, there's an online site, it's relatively easy to follow through. You can either file your mark as one that you're already using or you're planning on using, and then you tell them what goods and services. It's fairly straightforward. You can sort of go look at it on your own if you want. It's, well, kind of a boring administrative website, but still. So sometime around 6 months or so, you'll get an office action. You get a chance to respond. You may have to amend your goods and services. You may have to disclaim a component. Like Blue Wave computers, they might ask you to disclaim computers. So you can't claim the generic word, but you can claim the other parts. And then if there were clerical issues or the examiner wasn't happy with certain components, you have a chance to fix those. Like I said before, after you go through that process, once you've gotten the stamp, you go through publication. So basically everyone else in the world has 30 days to say, hey, wait a second, that's mine. They can request an extension of time, but it is a relatively small window that you'd be surprised how a lot of people do catch it. If you're a bigger company, you probably have the funding to look. For a smaller company, it can be a lot more difficult. Issuance, assuming nobody came forward, you get your new trademark. It's registered, you get a nice little certificate, it comes in the mail, and you get to use your mark. And if someone else is using it, you can say, hey, stop. There are maintenance things you have to do. Basically, you have to show the trademark office, hey, we're still using it, we're still selling these goods. But other than that, your trademark is perpetual, so long as you keep using it.
How often are the intervals?
First one's at between the 5th and 6th year, and I believe it's every 5 years. So it's quite a long time. And over time, you can actually sort of adjust it too. The sun-kissed raisin character, the lady on the package, has actually changed over time while they still have the mark. Intent to use is just a second type of mark. It's basically you get to register before you started using. You're basically telling the trademark office, hey, we want to do this. In the video game space, you'll notice a lot of games get intent to use applications just before they get announced. That's sort of the new hotness in discovering leaks. And it's basically you have about 2 years to start using it from once you've gone through the process, or else you have to do it all over again. Just a quick sort of pedantic moment, use of TM versus the R circle. TM, you stick it on you can do it yourself, stick it on anything you think is a trademark of yours. It's telling the world, this is mine, I think it's mine. The R is to signify that you're registered. So you're only supposed to use it if your mark is actually registered. Domain names are sort of a unique case. You can potentially register them as a trademark if you're using your domain name as the way of identifying your goods and services, but you're going to have to disclaim www.com or whatever other top-level domains you're using. It depends sort of how they're used. Infringement, you can probably guess, is very similar to copyright and patent, but in this case, it's whenever someone's using something that's confusingly similar. So if something happens to look a lot like your mark or something like that, that's when you're in infringement territory. But it also depends on what goods and services you're offering. In some cases, if you're in two completely different industries, if someone's in swimming pool manufacturing and you're in software, you're probably not going to cross, you're probably not similar to each other. Contributory, pretty much the same thing as the others. You are either helping with it or encouraging other people to do it. Likelihood of confusion, like I was saying, that similarity, we're still in the Ninth Circuit. It's the test that a court would go through to determine infringement. I'm not going to go through each one independently on their own slide, but basically, how strong the mark? Is it one of those Xerox Exxons that's super strong, or is it something that's closer to suggestive? How similar are the goods? Are the marks actually similar? Are they the same word? Are they close? Can you prove that there's actually people out in the marketplace that are confused? Have you had customers saying, hey, I saw this product, is this yours? What kind of marketing? Are you a high-end retailer that really only markets by word of mouth? Are you someone who advertises on Amazon, whatever your particular, the intent of the other party is looked at? And how likely are you to cross? If you keep sort of expanding your businesses, are you going to end up in each other's territory? Trade secrets, we're going to go really quick, but basically trade secret covers that big log of text, which basically describes things that you have as a business that are valuable to you because no one else knows them. Something your, as the idiom would be, your trade secret. Formulas, patterns, compilations, programs, device, pretty much anything you can think of. Derives its value from being unknown, and you've actually tried to keep it secret. If you put it, if you put your recipe on the box of goods or whatever it is you sell, not a trade secret, but if you try to keep it secret. But if you're WD-40, the New York Times bestseller list, KFC, or Coca-Cola, and you've taken steps to keep your recipes secret and you force people to sign NDAs, you don't tell anyone, those are trade secrets.
Are there actually any trade secrets in game dev?
In which?
In like the games industry?
Sometimes certain techniques can be, like ways of programming, structures, things like that. They can end up in that area. Really depends on how open you are with your community and how, if you have if you're perhaps your particular way of designing your engine or doing graphics or certain particle effects might be, provided you're not making it obvious how you do them.
Yeah. Also 5-minute warning. Sorry.
Okay. We're almost done. Again, with trade secrets, we just have to figure out what it is we have that's secret, and then distribute on need to know. We want to require confidentiality. Designated confidential. Don't let make sure your employees or anyone you work with knows this is something we're keeping as a secret. And don't let don't have monitors with your trade secret on when visitors are walking through. Advantages: no registration. They can cover lots of things and are protected by both state and relatively recently federal law. Disadvantages: once it's gone, it's gone. If it gets out of the public, you've lost it. They can be expensive because now you have to secure them, you have to sue people to keep them from disclosing, and it has to be something that is secret. If someone could figure it out easily, it's not a trade secret. Just one brief slide on licensing. You can pretty much license any of these types of IPs. Rights to make derivative works, produce, make, whatever. Sometimes they're exclusive to who you're licensing them. Sometimes you let lots of people do it. And really the only limitation is your imagination and what the other party will be willing to agree to. Just general advice, how to avoid it. Don't use other people's stuff without permission. Don't copy things. Don't try to confuse people. Don't steal other people's inventions. It's sort of pretty straightforward. General information, I've seen it online. This drives me nuts. The whole it's easier to ask forgiveness than permission, except in the law, kind of like medicine, because it usually comes with a fine, damages, or a settlement payment, and those can be huge. And usually permission and licensing fees are cheaper, and if they don't let you have it, they're going to be the people that sue to keep you from using it. General costs, just some things to consider: registration, maintenance, enforcement. Registration is relatively inexpensive for copyright. Trademarks a little bit more, and patents can be quite expensive to obtain. But just some general estimates of the maintenance fees, and that's over decades usually. Enforcement: there are third-party monitoring services you can employ that will look for your trademark and things like that. But enforcing a mark through litigation can be very cheap. The cost of having a lawyer send a nasty letter, or it can be $1 million litigation. So you got one of those nasty letters. Don't panic. Read it carefully. Please consider what you're talking to a lawyer or really consider what you're responding. I have seen it where someone responds on their own and accidentally says something like that could be construed as an admission of infringement or something like that, and that will haunt the rest of the process. There is no guarantee to prevent being sued, no amount of searching, but generally speaking, if you're being sued, you did something right, you're popular, you got somebody's attention. So there's at least that silver lining. Just some general information. I know attorneys can seem hard to talk to, we can seem uptight. Most attorneys, especially mid to small firms, will at least offer a consultation for free. It would be 15 minutes to an hour to talk to you about your problem. And shop around. Find an attorney you like. Just sort of repeating what one of my professors like to tell us, you're a facilitator and a risk advisor, we're not a gatekeeper. We shouldn't be standing here telling you, no, you can't do that. We should be telling you, that's risky, maybe try these others. And then just a quick plug for Washington Lawyers for the Arts. It's a nonprofit group that helps artists, just through monthly clinics. Currently, one of them is held at Amazon's Doppler downtown. I think it's the first Thursday of every month. Thank you. But the schedule's on their website. That's it. Please like and subscribe. Oh no, wait, wrong meeting.